Hey, welcome to another episode of CVN's Trial Technique Spotlight. My name is Shane Reed, and if you don't know me, I'm a trial consultant, an adjunct professor at SMU, and I've written books on trial techniques. Today, we're going to focus on cross-examination and one of the most important things you can do as a lawyer to succeed, and not many lawyers do this. I'm going to highlight Arash Homampour, one of the great trial lawyers in this country, and he executes at the highest level what we all should be doing on cross-examination. So let me give you a little context for his case. He was representing a bicyclist who was riding their bike in the parks of San Diego and was hit and paralyzed by an oncoming car by a driver who was on meth and driving twice the speed limit and going around a turn in the road that had all this vegetation, so it became a blind curve. So Arash Homampour was suing the city of San Diego, claiming that there was a defect in the road and the vegetation, and they should have known that an accident was going to happen and should have designed it better and then cut back the vegetation. We're on cross-examination, and the city of San Diego has on the witness stand the supervisor of liability for San Diego. And she's asking him about the coding of accidents to show to the jury that, hey, the city of San Diego had no notice of any problem with this turn in the road that ultimately caused the accident of the plaintiff that Arash Homampour was representing. But watch what Arash Homampour does. I want you to listen to a couple things. One is, as soon as the direct is over, he immediately shows his command of the courtroom, walks up to the witness, and grabs the documents that the witness has just been testifying from. Secondly, not only is he listening, he's able to think on his feet and craft questions immediately to show that the city's coding of this accident were so wrong that there's no way anyone could have ever been put on notice that there was a problem in the vegetation or problem with the signage or problem with the design in the road because it was not coded properly. And then finally, what he did so well is he noticed, because he was thinking quickly on his feet, that this liability supervisor noticed that on the coding, it had actually been coded to say that the roads were under the supervision of the city of San Diego and not the parks. And that was very important because another defense witness had taken the stand and said it wasn't the responsibility of the city of San Diego because this was a park road and that fell under a different jurisdiction. So let's watch and then we'll talk about it in just a moment.
So based on the database search that was conducted, was plaintiff's claim, the one that we're here for today, as a result of the August 12, 2014 accident, was that the first notice of claim or lawsuit to the city of San Diego of any possible dangerous condition regarding wrong-way drivers or overgrown vegetation before August 12, 2014?
Yes.
I don't have any other questions, Your Honor.
CrossExam?
Where are those search results? Sir, I don't mean to be rude. Do you have the search results that you just referred to? In your
Yes.
Can I see them? Can I approach them?
Sure, I have to unstaple it, that's okay.
Okay.
There you go.
As far as you know, these have never been given to us, correct?
I'm sorry? Can you please read that?
I'll say it again. As far as you know, these were never given to us, or was this search result given to us?
Objection argumentative and also assumes facts, not in evidence.
Sustained.
Do you know if this was ever given to us?
I do not
Calls
know.
for speculation.
Hold on. Slow down. That's a personal question just to you, sir. Understand? Just to you. Do you know? You may answer.
I don't know one way or the other.
And the subject incident is listed here, and the only thing that talks about details is the remarks section, correct?
Correct.
And how someone coded this incident is private auto versus bicycle alleged road design defect, correct?
Yes.
So this incident was not coded as anything having to do with signs, correct?
Not specifically coded that way, no.
No one typed in missing signs in the description of this incident, correct?
Correct.
No one typed in overgrown vegetation, blind corner, or anything of that nature in the remarks for this incident, correct?
Correct.
So if someone asked you to search a claim relating to a blind corner, this incident wouldn't be pulled up by using the phrase blind corner, correct? Correct?
Correct.
If someone searched for signs as an issue, this incident wouldn't come up, correct?
Correct.
I guess you would see it if you typed in Fiesta, correct? You would see this incident if you typed in Fiesta, right?
If you do a location search with the word Fiesta Island or Fiesta Island Road or the search terms that are included on that report, then it would show up.
But whoever then sees this incident show up if they typed in Fiesta would not know it related to an allegation of a blind corner or lack of signs, correct?
Objection, relevance.
No, overruled.
You can, unless you look into the details of the claims.
And the asset owner was determined by the city of San Diego for this claim to be?
Objection, assumes facts not in evidence regard in this case testimony.
Last time we're asking that question. Overruled, you may answer, sir.
Again, the Fiesta Island is an asset of Park and Rec, but Streets does have some maintenance responsibility. This claim had an allegation related to signage, road defect, or whatever it was, and so the employee, the claim rep, chose transportation and stormwater because traffic engineering falls under that.
All right, wasn't that video just really fascinating? I just love so many things that Arash Homampour did. I just want to talk about a couple of them. We've already talked about how he listened, but you could just tell from his confidence, from his tone of voice, that he was in charge of the courtroom. He goes up and gets the documents, he reads them quickly, he adjusts his cross-examination, and he notices that the coding is incorrect. So the city never could have been on notice about prior problems with this curve in the road because of their coding system. And then secondly, he thought, oh my gosh, I noticed on these coding sheets that the city has admitted that they were responsible for the road, and that's inconsistent with another one of the defense witnesses who said, you know, this is a park road and not under the maintenance of the city. He's thinking on his feet, he's listening. Arash does what I wish all of us out there would do better, is listen, pivot, show confidence in the courtroom. And because of that, not only does he win the trial, but he gets this huge settlement from the city of San Diego for approximately $24 million. So I hope you enjoyed this tip. For great more tips out there on CVN, just go to their library. They've got a vast library, and you can find more examples of Arash Homampour there and other great trial lawyers. I can't wait to see you next time on CVN.